In public education, we work with all types of kids, but our fastest growing population may surprise you. It's our students who enter school needing extra support in academic English. We call these students English learners. English learners, or ELs, have some level of exposure to another language, which may affect how they perform in school. So, we provide ELs with special supports to get them ready to learn, ready to live, and ready to lead. Georgia is 8th in the nation in terms of its number of EL students, and much of how we work with ELs is based on regulations developed by the Federal Office for Civil Rights, a law enforcement division of the U.S. Department of Education. So today, let's look at some of the basics of OCR law, because it's important that all public K-12 schools understand the foundational services that must be provided to this rapidly growing population in our state. So where do we start? Let's review some history. The Federal Civil Rights Act of 1964 forms the basis of all of our language support programs. For over 50 years, schools have been required to identify all potential ELs, screen these students to determine their academic English proficiency, and, by law, rectify any language deficiencies discovered. A few years later, the Office for Civil Rights put out a memorandum which added the requirement that schools adequately notify EL parents of school activities that other parents were receiving notification about. For some parents, this notification might need to be in another language in order to be considered adequate. In 1982, a Texas court decision made in Plyler v. Doe was contested and brought to the U.S. Supreme Court. The Supreme Court ruled that no K-12 student may be denied a public education based on their legal status in the U.S. This is why we can't require Social Security numbers, for example, or make any request of a parent that might be considered exclusionary or chilling to those who may be undocumented and are trying to enroll their child in school. So now we know the federal requirements for serving English learners, but let's get down to brass tacks. What does my school need to do in order to comply with federal law? The first step is thinking about your student registration process. We need to be certain that each school is appropriately identifying any student who could potentially qualify for ESOL services. We should also make sure that communications that go out to all parents are also understandable to our EL parents. That may mean translation or interpretation is required. Detailed guidance about this requirement can be found on our state ESOL webpage under the heading Federal Resources. Each EL should be receiving English language support services in a manner that's compliant with civil rights requirements. Our state ESOL delivery models fulfill this requirement. Schools employing innovative delivery models should verify with their district ESOL staff that the model in use is also OCR compliant. Finally, make certain that your school's English learners are provided opportunities to participate in the full complement of programs, services, and activities offered at your school. If a student qualifies for a program, such as Gifted, they must be offered a place in that program. It's important to note that no one program trumps another. So, if an EL requires special education services, for example, by law, he must receive both ESOL and special ed support. So how do you know if you're doing all of that? Well, talk to your ESOL teacher and your district ESOL coordinator. Ask them, how are we identifying our ELs? Are we using these instruments? What is our identification timeline? What are we doing to include and engage the parents of our English learners? Are there other or better ways we can reach out to them and get them involved in their child's education? How about our ESOL program? Are all of our language support staff ESOL endorsed or certified? Tell me all of the ways we provide language support to our ELs. How is it working? Do the students' test results indicate that our program is successful? How often do we analyze our data? Where could we improve? And finally, has every EL been assured of equal access and participation in every facet of our school community and programs? In the end, it's important that we remember these 4 critical points. All students have a right to a public K-12 education. And for that education to have meaning for our English learners, language support is both necessary and required. That support should be given in a manner and facility similar to other support classes for the student population. EL parents should be provided important communications in a way that those parents can understand. And EL students should not be excluded from any program for which they may qualify. If you have any questions or need additional information, please visit the Office for Civil Rights website, where you will find laws, more in-depth guidance, and FAQs related to all we have discussed today. You now know some basics of federal civil rights law as it relates to our English learner students. Thanks so much for sharing your time with us today.